Hey everyone, big news. Sorry, let me get this on. Sorry about the shakes. Everybody there? Everybody there? Big news. Okay, all right. Let me make sure I can see the chat. Hey guys. It's good to see everybody here. All right, the chat is flying. And I can't go in and change it right now, so I hope that it's slow enough, because happy Friday, everyone, except for Vallow Daybell, because I'm pretty sure she's not having a good Friday after Judge Boreski responded to all of her motions. The judge himself has now responded to Vallow Daybell. So we're going to read this together. And yes, this is called, thanks guys, this is called On a Whim Live. I have some place to be in an hour. I'm at one appointment. I jumped in the car. It's hot out. I've got both doors open on either side of me to let some wind in, but the car's off so you guys can hear me, and we are going to break this all down. Let's go. Let's go. So here we go. Judge Boreski came down on the docket. First off, he is going to break down each thing that she requested. The first is the court has received and reviewed the following: defendant's motion for a new trial, filed May 1st, 2025, the state's response in defendant's motion for a new trial, filed May 6th, and the defendant's reply to state's response to defendant's motion for a new trial. Boom, boom, boom. All right. All right. So, first off, lifting, you know what? The wind tunnel's not working. We can't hear anything. So I've got one door open. All right. That's enough. Lifting of the admonition. Oh, here we go. Sorry, I jumped ahead. The court will address the issues in order which will appear in the defendant's motion. Number A. Letter A, juror misconduct. The defendant alleges there was juror misconduct based on a statement Juror 15 made to reporters following the verdict, wherein he stated, "You know, I feel very sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell," end quote. On its face, the statement would seem to indicate the juror violated the admonition and researched the defendant's acquiring knowledge about her sentence imposed in another matter prior to the lifting of the admonition. However, the state's response included multiple additional media clips of statements Juror 15 made both immediately prior to and after the statement referenced herein, of which he denies any knowledge of the defendant's other case sentence prior to the court releasing the jurors from the admonition. At best, Juror 15 gave a single statement, which seems to be in conflict with all of his other statements, which he specifically denied any misconduct. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct, as contemplated by Rule 24.1, the court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice, or if it can be fairly be presumed from the facts, and then case law is cited. So in other words, he clearly had no prejudice if he was considering that Vallow Daybell was perhaps not guilty. And there is no prejudice of this defendant. Thus, there is no juror misconduct. B, preclusion of Tylee Ryan and Alex Cox's statements and impermissible testimony by Detective Daniel Coons. Now remember, Detective Daniel Coons, he was the ballistics expert witness. She does not think he should be an expert witness, and she is upset that Tylee Ryan and Alex Cox's statements were precluded from being able to be part of, her testimony or evidence in trial. So Judge Varesky's response. I love it. We have only 2,000 people in chat. If by chance Troublemaker Baker is here, which she probably isn't because she had no idea I was going live, if we could slow down the chat. But we're going to do this. Oh, it does look slower. Maybe she slowed it down. Thanks, guys. All right. Preclusion of Tylee Ryan and Alex Cox's statements of impermissible testimony by Detective Coons. The court issued a preliminary pretrial ruling on March 11th, 2025, regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. And that is true. I was at that preliminary pretrial ruling hearing. Sorry, can't happen. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox appeared to be hearsay, and a defendant failed to establish that any specific statement was either non-hearsay or fell within an exception to the rule excluding hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by stating that the defendant could re-urge the issue outside of the presence of the jury. Not only did the defendant never take the court up on its offer during trial, the defendant's motion for a new trial and reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exception to the hearsay rule. I mean, I love it. Judge Varesky talks exactly like he talks in court. Like, look, hey, let me walk you through this. We need some specifics, not just generalities. But hey, you can bring this up, Lori. Here you go. Let me spoon feed you. I love it. He's like, so let's remind you one more time what was said in that pretrial hearing. So let's keep going. As to Detective Coons' testimony, the defendant argues that the detective did not have foundations to testify as an expert. Sufficient foundation was laid for the Detective Coons, to give his opinion on ballistics again, and the defendant has offered no specific information as to what additional foundation should have been required. So in other words, on the stand, Detective Coons in his testimony laid foundation as to why he would be an expert in his specific testimony. It was laid, it was great. And the defendant, who is Lori Vallow, offered no specific information as to what additional foundation for him to be an expert would have been required. To the extent the defendant, Lori, believed the witness was not qualified. That was the only reason she gave, that he was not qualified. But Lori, we need just a little bit more, the judge is saying. Give us something. So, or her opinion, unless she gave us more, should not be given weight by the jury. She did have the opportunity to cross-examine this expert witness about his qualifications or lack thereof, as well as the basis for his opinion. But she didn't do that. She didn't do that, in other words. The defendant also argues that she did not have time to rebut Detective Coons' testimony. The record is clear that the defendant was offered more time to prepare for trial. She was offered a continuance, but she declined. She was not going to waive her right to a speedy trial. Moreover, the argument that the basis of Detective Coons' testimony was the walkthrough of Alex Cox's house is not supported by record. In other words, he didn't testify to that. The defendant's reply, for the first time, Lori Vallow's reply for the first time, very first time, raises the additional argument that Tylee Ryan's statements also formed the basis for Detective Coons' testimony. Again, there's no evidence of this, and the defendant offers no specific statement by Tylee Ryan or Alex Cox to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Coons somehow contributed to his opinion, the defendant never asked the detective those questions. Or did anything Alex Cox show you? In other words, now this is funny, Judge Varesky is laying out a question that Lori could have asked. Like this, he puts, i.e., for example, here's a question, Lori, you could have asked. Did anything Alex Cox show you or tell you contribute to your opinion? ? This type of question, Lori, would have been permissible. However, the defendant, Vallow Daybell, did not ask it, or nor was ever precluded from asking that. The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been allowed under the rules of evidence, nor does the defendant establish Detective Coons' testimony was improper. So, there you go. Like, Lori, you could have done this. Lori, you could have done that. Lori, you could have asked this. Lori, you could have asked that. You didn't do any of these things. Now, there's also a footnote at the end of this page that I just skipped, which actually takes us back to letter A, the juror, the single statement from the juror, Carl, juror 15. So those footnotes actually, I think, are kind of important. So I'm going to now step back a little bit. Let's read these footnotes. Number 1. So back to juror misconduct really quickly. If there were misconduct, the defendant's own motion undercuts her argument that prejudice exists because she points out that juror 15 stated he was leaning toward not guilty throughout deliberations, a distinct indication that if juror 15 did have any extraneous information at that time, it did not affect his consideration of the evidence. Number 2 in the footnotes about jury misconduct. Neither the state nor the defense chose to have an affidavit prepared by juror 15 or any other juror, so the court is left with the media clips provided in the pleadings. In other words, the court is, that's great. Let me read that one more time. Neither the state nor the defense chose to have an affidavit prepared by juror 15 or any other juror, so the court is left with the media clips provided in the pleadings. That's hidden true crime. So glad we could help out there, as well as Carl explaining. So C, discovery violation. Discovery violation. Although defendant's motion alleges the contents of the hard drive are exculpatory, she never articulates a single item whatsoever that would constitute exculpatory evidence. So in other words, we're jumping to the fact that Lori complained and has whined over and over and over again that if she could get her own extraction of Charles Vallow's phone, of her late husband's phone, that she's now convicted of murdering, her murdered husband's phone, that it would be evidence so damning, it would pretty much mean she was innocent of this crime. It's so extreme that the judge said, look, the evidence is so compelling, according to Lori, that the judge was like, do you want to do a continuance on this trial then? Do you want to wait till you get Lonnie Dworkin to be able to testify and we get this evidence that you say is that good? And Lori was like, no, let's move forward. And the judge gave her all the opportunity in the world to get this own extraction of Charles Vallow's cell phone. Didn't happen. Didn't happen. Mid-trial, the judge is like, too late. So now she's saying there was a discovery violation because she couldn't get this extraction in time because it would have meant she was innocent. So the judge is addressing this and saying, look, you have never, Lori, been able to articulate a single item whatsoever that would constitute exculpatory evidence, not once. And the judge says, again, merely stating something is exculpatory does not make it so. I love this judge. I mean, but it's true. He's speaking truth. He's dropping truth bombs right and left, but he's talking. He's like, let me put this to you in the most simplistic terms, but welcome to Vallow Daybell's mind. Just because you say something doesn't mean it's true. And the judge is spelling that out. But this is essentially who Laurie Daybell is. She really believes that if she says something or she thinks something, it's true. Right? Like, that's what kind of like drives us all crazy. And this is no different. And the judge is like laying it out. Just because you say that this evidence would claim you're innocent doesn't mean it's true. Give me something. So here we go. She never articulates a single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is exculpatory does not make it so. The defendant's request for additional discovery relates to Charles Vallow's phone, and this was accommodated. The state has previously disclosed all evidence it had in possession at that time. In other words, Lori was given all of discovery. The defendant requested access to the actual phone to run her a new examination with software that has been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. In other words, she was given the phone. Go for it. Do your own. Let's figure it out. Nothing has come from this. The court finds no discovery violation. Yeah. Now, here we go. D. I keep wanting to say number D. Letter D. Prosecutorial misconduct. Let's hear what Judge Boreski says about that. The court finds nothing in the defendant's allegations comes close to prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should be interpreted differently. I love it. Hey, by the way, Lori, you do not have to agree with the state and those inferences and is permitted to argue the evidence should be interpreted differently. The defendant, Lori, argues in her reply for the first time that both the state and the court violated the defendant's right under the Religious Freedom Restoration Act, the RFRA. And although new arguments are not to be considered when first raised in a reply, the court will nonetheless address this. The RFRA protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. Right, exactly. Right. It protects religious freedom. The Religious Freedom Act does that. But there's no conduct but either the state or the court that somehow infringed on the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chooses to believe. Moreover, the Religious Freedom Rights Act does not protect someone from committing criminal acts in the name of religion, nor does the act prevent any person from disagreeing with another's belief system. So in other words, we can disagree with your belief system, Lori. You don't have to be right, and you don't get to be protected from committing a crime. Here, different witnesses may have had different interpretations regarding who Nephi was or the significance of Nephi's story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. For those reasons, the court finds no prosecutorial misconduct. E. Court's lack of impartiality. The defendant alleges the court was not impartial because the court struck two of the defendant's witnesses from the defendant's witness list. Contrary to the defendant's assertion that no rule or law or evidence requires her to establish a witness has relevant information, Arizona Rules of Evidence 601 and 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses would provide, which the defendant was unable to provide. I saw that firsthand. He was like, how are they relevant? She wouldn't say a dang thing. The defendant was unable to provide this. And when the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue. Thereafter, the defendant did not again offer any witness, even though she was specifically told she could re-urge the issue. And I was there. The judge said that. Bring it up. In addition, in her motion for a new trial, the defendant offered no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question of the court, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, it does not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, the court acknowledges the court's comment was unnecessary. That's a win for Lori. And the court should have simply overruled the state's objection without comment. Okay. Now, what we're talking about, for those that remember, is when Judge Boreski stated, in regards to you comparing yourself to religious, I think, prophets, I will allow it. The judge is saying he should not have made that comment. He should have just overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. Having carefully considered defendant's arguments, all of the briefing and the record, the court finds the defendant received a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial under AR CRIMR 24-1C. It is ordered denying the defendant's motion for a new trial filed May 1st, 2025. There are a couple other footnotes. Let's read them together. There's a footnote to this specific thing. Footnote 1, the defendant's reply seemed to argue that the defendant was precluded from calling all 12 of her witnesses, which is not the case. The defendant chose not to call any witnesses during the defendant's case in chief. Exactly. So she's upset that certain witnesses were precluded, but she did not call any witnesses in the end. She didn't put on a defense in the end, if y'all remember that. Like, in the end, she was fighting to have witnesses, right, for this trial where she was just convicted of murder. She wanted witnesses. And in the end, she didn't call any witnesses. And now that she has a conviction, she wants to argue that it wasn't fair. Lori. Let's see if I missed any other footnotes. I think I got all the footnotes. Okay. So, yeah. I'm going to check out chat now. I've got to go run back in. It's a busy Friday. I thought I'd be like taking a little break from going live because if you don't recall, 2 days ago, I went live saying, thought I was done with Lori Vallow for the week. And then yesterday I went live thinking, thought I was done. And the docket just keeps bringing it. And Judge Boreski, oh my, when I read that, I was like, I've got to go live right now. Got to go live right now between appointments here. Looking at what you're saying. It isn't that Lori doesn't want to call witnesses in to vouch for her. The problem is that nobody wants to come to court and do that, including her own mother and sister. It's a good question, you know, who doesn't want to come? And yeah, a lot of people don't want to. And, you know, it's also, she's admitted it. It's a game of cat and mouse. So let's say she can call some witnesses. What are they going to say? You know, it's interesting. All right, guys. I'll try to maybe even go live later tonight. Hit notifications because I might bring us some more tea later tonight. There's more coming down. And we have some updates on Koberger as well as, I'll just say a lot more. Oh my goodness, Jen, thank you. Thank you so much. I needed that. I've also got to start putting my phone microphone in my purse wherever I go. My problem is I don't like purses. I carry around a little tiny little, you know, a crossbody, but I will start carrying my phone mics around so that I can have better sound. I'm gonna go get out of this hot car. The door is open, but it is hot in here. And wow though. This was a good response from the judge. He laid it out. He spoon feeds her everything once again. I actually felt he was pretty patient in this, and he did acknowledge that he should not have made comment on that one moment. That was true. I did have concerns about that. And someone else wrote me and said they had concerns about what the judge had said in that moment. But he still does not see that equaling the fact that she didn't have a fair and impartial jury trial. All right, guys, I'll take off. Thanks for being here. Thank you to my moderators who jumped on here too. Thank you for your support, and we'll see y'all soon again. Bye-bye.